Any mention?
Yes, my lord.
Yes.
My lord, I'm mentioning item number 26 and 30. It's a hearing list. Oh, sorry. Yes, I have a sore.
Yes.
I'm for responding.
I have a little sore throat, my lord. It may just affect my submission. That's the reason why.
How much time you want?
Yes, my lord.
Next week or whatever.
I need just a week. I'll be okay by next week.
Okay, 26 on the request, on behalf of the petition list after the week. Yes.
And similar matter, my lord. Another matter. Item number 30. 30.
At number 30.
I'll sign the other side.
Wait, what happened to you? Too much into partying.
No, not at all, my lord.
30 is similar thing. There is also.
Yes.
No,
No
okay,
objection.
this
Lordship.
30 are for the state respondent.
Yes, my lord.
30 will be on the request of the state respondent. Yes.
What's obliged, man?
30 1 week or 2 weeks?
30.
Item 30 1 week or 2 weeks? 2 weeks.
1 week, I'll be fine, my lord.
My lord, item number 28. Item number 28, I am for the state.
Yes.
Here the matter is referred to the mediation, lordship. 28, lordship. So, wait, the mediation.
Referred is referred
day after
to the
tomorrow,
mediation.
lordship. Day after tomorrow is this, yes, lordship.
So why it is listed then? If it is
After 2
referred
weeks,
to
lordship.
mediation,
After 2 weeks, lordship.
it is. If it is referred to mediation, it is listed. 28. Is it correct that it is referred to referred for mediation?
Yes, lordship.
Okay.
After 2 weeks, lordship.
28, item number 28.
Okay, just on request made by the parties listed at 2 weeks.
Awesome.
May I please, Your Lordship? Your Lordship, I beg to mention item number 24.
Yes.
On behalf of Jaishallah, Your Lordship.
No objection, Lordship.
2 weeks.
No objection, Lordship.
24 2 weeks on the request of the petitioner. Yes.
Obliged.
Right.
May I play, Lordship?
Yes.
My lord, item 12, my lord. Requires a week's.
No objection, Lordship.
2017 matter, Mr. Yeah.
My lord, next.
In prayer of the petitioner not objected to by the respondent, list after 2 weeks. Yes.
Obliged, Lordship.
Please, Your Lordship. Lordship, I beg to mention item 21, Your Lordship. Your Lordship, in this matter, the parties are in the process of settling the matter. We are yet to bring the settlement on record, Your Lordship.
Oh, that has been settled.
Yes, Your Lordship.
It has already been settled. It's just that they have to bring it by way of an affidavit on
Yes,
record.
Your
The settlement agreement.
So,
2
when do
weeks,
we
Your
want it?
Lordship. After 2 weeks, Lordship.
This is a matter where we have passed an order that you sought time to bring on record.
Yes, Your Lordship.
Okay, just say one request made by the parties. List this matter after 2 weeks to enable the parties to bring on record the terms of compromise attained by the parties.
Obliged, Your Lordship.
Mr.
Please, Lordship.
Yes.
Lordship, I beg to mention this item number 8 and 9, Lordship. Lordship, here we have already filed our service affidavit, Lordship. And the state have filed their counter affidavit to our application, misapplication. So those matter can be heard, Lordship. Next, after 1 week, Lordship.
This you are mentioning item number 8.
8 and 9, Lordship.
These are in the hearing list already.
Yes.
Yes.
In the hearing list, Lordship.
These are 2014 matters.
Yes, Lordship.
So what affidavit is filed now?
The implement and the striking off of the name of that new representative of that CMJ, Lordship.
Okay.
So the state have filed their
You have filed an application for
implement of the new
implement or striking off.
implement. Yes, Lord. 2 applications,
Okay, and then
and they have filed their counter to that, so it can be heard, Lordship, on the next date.
May I please, Your
Because they have prayed. If you see the previous order, Lordship, they have prayed for hearing the matter together with the main matter, Lordship.
in the miss case.
Yes, Lordship. So it can be heard on the next date, Lordship.
So how come implement will be hard with the main matter? Implement will be hard before
Because
the
they
merit
have
is
filed their
taken up.
affidavit. That is their prayer, Lordship, and prayer
Is
and
there
Lordship
prayer?
has allowed.
But then it
May I
cannot be.
please,
Yes.
Your Lordship, I am appearing on behalf of learned ND Shulai AG. So he's on his legs. So today, only for today, Your Lordship.
No, it's okay. You have only for today, but then
Because we have
Then
some
matter may-
difficulty today, Lordship. That's why we
Mr.
are
Dakar
asked.
here he wants more sense. Okay.
Then when the
Let it come after 1 week, Lordship.
So 1 week will be all right, and will be all right. Then just say one prayer made by the parties. Item 4. One prayer made by. On joint prayer made by parties. This is matter after a week. But
Lordship.
then these orders will be this. Have you passed any separate order in this case?
No, in the main case, Lordship, it was passed. The missed case has yet to be taken up.
Just see the order sheet, check both the miss case and all, and then place the order. Yes.
Lordship. I have similar prayer for item number 17, Lordship.
much pleasure.
17.
Item 18-9 will be after 1 week, and then 17.
17, let it come after 2 weeks, Lordship. There's an appeal pending, Lordship, which will have a bearing in this matter, Lordship. Concerning the same
Appeal pending where?
before the division bench, Lordship. Division bench.
And what is the issue involved here?
Here, the suspension of this aim, Lordship. So, and this one, in this matter, we are challenging the inquiry, the charge which are charged in the inquiry report, and they are challenging the inquiry report, Lordship, because they have been suspended.
So this will
So
be
that
dependent.
matter is pending before the division
So
bench.
it will be dependent upon the outcome of that appeal. Has it been
Yes,
recorded here in this?
Yes, Lordship.
Is it the fact?
Your Lordship have to seek instruction on the same for respondent number 4 regarding the appeal that's pending before the division.
Whether
An appeal is pending.
you say it is already recorded here in
Yes,
this
Lordship.
case.
That was the similar submission we have made in the last occasion also. Lord.
You have made whether that has been recorded or not.
Yes, Lordship.
Are you sure?
Yes, Lordship.
Okay, just this 17. You just verify the previous order and just make it. Any objection to the prayer?
No.
And after
After 2 weeks, Lordship.
after 2 weeks, that appeal will be disposed of.
Lordship, let it come after 3 weeks, Lordship, because there's a
Can
bench.
you just keep it for 3 weeks and just verify the last order and prepare the order? Yes.
Hello, Black.
Lordship, I have similar prayer for item number 15 and 16. This matter has already been heard, Lordship. The state is yet to file their written submission.
You have filed your written submission.
We have already filed, Lordship. We have already filed.
Now you have to refresh the court again. Then this will be. When was it heard?
It was heard, Lordship. It was heard in the
Sometime in the month of.
even the written submission have already been filed. Now the state are seeking time.
My lord,
One
our
after
written
another,
submission is ready. It will be filed now only.
In the last occasion, they said they will file in the course of the day, Lordship.
Some corrections were there, my lord.
They did not file.
If you say something, you
My apologies, my
fulfill
lord.
it.
Some corrections were there because that day I received my friend's written argument, my lord.
When do you want it?
Subject to my, because we've already filed a written
He says he's
submission,
ready
Lordship.
with the written thing.
Yes, written argument
Let
is
him
ready. my
file,
lord.
Lordship.
I'll be
Then the
filing
matter
it now
can
only.
be
my lord.
reserved
Okay.
for judgment.
Just 15-16 you just say. Mr. Kavi Bhattacharya, London State Council, GA pen for the state respondent submits that notes on written argument on behalf of the state would be filed during the course of the day. Same view of the submission. This is matter after a week. Yes, both 15 and 16. Okay. Yes.
Obliged, my lord.
Lordship, I have one more prayer, Lordship, in this item number 22, Lordship. Item number 22. Lordship, this matter, I'm praying that it can be listed together with this matter, Lordship.
Which matter?
There's a new writ petition which is filed, Lordship, by the same writ petitioner challenging the...
When this new writ petition is coming up?
The dates is not given, Lordship, but it's saying in the last order that after
We'll pass
2
that
weeks.
order in the new writ petition, not in this writ petition.
Yes, Lordship.
When this new writ petition comes up, you say about this. For the timing, we'll adjourn. When this new writ petition is coming up?
After 3 weeks, Lordship is showing in the last order.
After 3 weeks.
So let this matter come after 2 weeks, Lordship. After 2 weeks.
Okay, this is, yes.
No objection, Lordship.
Okay, yes. You to say on prayer made on view of the petitioner. Not objected to by the Land Council of the respondent. Disturbed for 2 weeks. Yes. You say this, the new matter when the pleading is complete, when it's ready, then we will get it because it is already in the order column. Okay, so any order to release them together will cause some inconvenience.
Yes, Lordship.
Okay.
Deeply obliged.
May it please, Lordship.
Yes.
Lordship, I beg to mention item 13. Your Lordship, this is a NOCMA matter. We are required to produce the records. We are yet to obtain the records, Lordship. I am praying for 2 weeks' time. Because of the certain issues, Lordship, now those have been resolved, so we are expecting to get it within 2 weeks, Lordship. For respondent 1, 2, and 3.
For respondent number 4 to 5.
Just on prayer made by Mr. Estep, Land Council applying for a son number. Joint row.
This was recorded in the last order.
List this matter after 2 weeks. Enable him to produce the related record before this court.
Much obliged.
May it please your Lordship, I beg to make a mention of item number 31. Your Lordship, the conducting counsel is out of station. I'm praying for 2 weeks' time.
Item 31.
Yes, your
Yes.
Lordship.
Yes.
No objection.
How much time you want?
2 weeks' time, your Lordship.
Okay. On prayer made on behalf of Mr. P. Yuvin. Honored legal aid counsel appearing for the appellant. This matter after 2 weeks. Yes.
Yes, your Lordship.
May it please, Your Lordship. I beg to mention item number 20. Your Lordship, we have received instructions to withdraw this petition. We'll be filing a formal application to that effect, Your Lordship.
For withdrawal.
Yes, Your Lordship.
You will be filing an application for withdrawal or you want
We'll
submission
be filing
to be
an
recorded?
application for withdrawal, Your Lordship.
Okay, so when do you want it to be listed?
2 weeks, Your Lordship.
2 weeks.
Yes, Lordship.
19 also on prayer for the petitioner, not objected to the electronic GA, list after 2 weeks. Yes. You 19 or this is item
20.
20, not 19, 20. Yes.
Obliged, Your Lordship.
Number 27, my lord. 27, my lord. This is that romantic relationship matter, my lord.
There is no sign of romantic matter coming to an end. Mr. Gurung is responsible for that. Okay, 27 also list after 3 weeks.
3 weeks, my lord.
Yes.
Same with 25. Item 25 is also same.
25 also.
25.
3 weeks.
But
May I please, Your Lordship? Your Lordship, I beg to mention item number 23.
Yes.
I pray that this matter will come after 2 weeks.
You are appearing for?
Petitioner.
And for the state,
Yes.
no objection.
23, 2 weeks on the prayer of the petition. Yes.
Lordship.
May it please your Lordship.
Yes.
Lordship, I beg to make a mention of item 11, Lordship.
Your Lordship, in this, Lordship,
Yes.
this,
Service matter pending from 2016. You are out of service.
Lordship,
This is a service matter, isn't it?
Lordship,
Your Lordship.
And you are out of service, isn't it?
Lordship, one has retired. The other,
Retired after filing the case or before?
during pendency, Lordship.
Yes. So it was not against their removal from service.
No, Lordship.
Now they're claiming pension and pensionary benefits, Your Lordship. One of the petitioner has passed away, Your Lordship. Your Lordship, this an order dated 02/05/2025. It was allowed for the wife of
Okay. So then some relief has been given.
no, Lordship. Your Lordship, they're just contractual and voluntary employees, Lordship.
What you are trying to point out now?
Your Lordship, there's one order that allowed the inward petition 260 of 2016 for substitution of the wife, Your Lordship. Your Lordship, I was not
There is a substitution application pending.
What is allowed, Your Lordship? Your Lordship, I pray that I may be allowed to file a recalling.
Disposed of.
Yes, Your Lordship. I may be
So
allowed to
then
recall.
thereafter the petition was amended.
No, Your Lordship.
Was it? The necessary amendment was made in the cost title? Was there?
No,
Yes,
Your Lordship.
madam.
Lordship,
In which case substitution was allowed?
Dhiren, 260, Your Lordship. WPC 260 of 2016.
Is it that case where this confusion was that one common order was passed?
Yes, Your
in three
Lordship.
matters?
Yes, Your Lordship.
And subsequently, in 2 matters, this was recalled.
Lordship,
Yes, Your Lordship.
And 1 matter substitution application.
Lordship, we had
Now,
filed.
you were supposed to bring on record no objection from other, isn't it?
Lordship, an undertaking.
Substitution was allowed. It was a conditional order.
Lordship,
So, have you done it?
Lordship, we require some more time. Lordship.
Many things you should tell us then.
Your Lordship, I may pray with that I may be allowed to file a recalling order.
What
in
you will
this
file?
case, Your Lordship.
There is nothing for you to file here.
Your Lordship,
Your chance of filing objection is over now.
Your Lordship, recalling of the order 0205/2025, Your Lordship, for I was not even present on that.
You
day, Your
were
Lordship,
not present, but then it was recalled, taking into consideration the facts and situation involved. It was because, you see, substitution was sought for in 1 case,
Yes,
but
Lordship.
an order was passed in 3 cases.
Yes, Your Lordship.
So if it is recalled also, it has no bearing on you. So why should you be worried about that?
Your Lordship, the Accountant General is not the appointing authority, Your Lordship, and now they're claiming a pension benefits,
There
Your
is no
Lordship.
problem. See, we are concerned with substitution only.
have our stand and we will reply at the time of hearing.
Isn't it?
Yes,
So
these are the
this
homeguards
court,
who were appointed and were terminated by the
Accountant
authorities
General.
who had hired them. So the home guards would like to place their arguments at the time of the final hearing.
Your Lordship.
okay. So far as that issue of, that means in 260 the issue of substitution is not yet over because they are yet to bring on record the no objection from the other.
Lordship, the
And this
undertaking.
order is there for quite some time.
Lordship.
Isn't it?
Lordships may grant me one more week's time, Lordship.
That will be done in 1 week.
Lordships,
You will give your undertaking.
Lordships, I undertake, Lordship. A week's time, Lordship.
Okay, we'll just common order will pass in all these things.
Lordship.
Just one prayer made by the prayer made on behalf of the petitioner. Not objected to by the learning council appearing of the respondents. List after 1 week.
Lordships. Lordship, a similar
Do
prayer
the
for...
needful.
Lordship.
Yes.
Lordship, a similar prayer for item 18 and 19. Lordships, these are connected matters. Lordship, I'm praying.
18 and
18 and 19, Lordship, these are connected matters.
yes.
Lordship, I pray these matters may come up after 2 weeks' time, Lordship.
Why? Why?
But in this matter, my lord, the government has taken a decision. My lord,
Why you are disturbed? Let her submit. You know,
no,
both
she is
of you
not
are
aware of that aspect. That is why, my
Let her
lord.
see. Let us see. Court has not
sorry,
asked
I'm
for
sorry.
your assistance. You just allow her. Yes. Why do we want adjournment? Just tell us. Court has not asked you about the fact of the case. Why you want adjournment?
Lordship, there are some developments, Lordship, in this matter.
What are the developments?
Lordship, where a decision was made by the government, Lordship, in terms of regularization.
Okay, so that means this matter might become infructuous.
Lordships,
Not very sure. Yes. When do you want it?
Lordship, after 2 weeks, Lordship.
Any objection?
No objection.
That same order not objected to this.
Highly obliged, Lordship.
Much obliged.
Alright. Mr. Lordship, I beg to mention item number 14, Lordship, on behalf of Mr. M. Chandan,
Anything
Lordship.
left in the list? Item 14.
Yes, Lordship.
Yes.
On behalf of Mr. M. Chandan, Lordship.
Yes.
I pray for 2 weeks' time.
No objection, Lordship.
Same order. Prayer not objected after 2 weeks. Yes.
Obliged, Lordship.
He record his name on behalf of so and so. Yes.
Item number 1.
Yes, Your Lordship. Your Lordship, the conducting counsel is out of station. I pray that this matter may...
You are there, what is the problem? Tell us what is the case about. Is there any prayer for interim relief here? Any prayer for interim relief in this case?
No, Lordship.
Let us just see. What is that? Can you tell us what is the matter? Are you there in the case? Your name is there in the case.
Yes, Your Lordship.
So you are there. Can you tell us what is the case?
Police synopsis.
You will not be able to tell. When do you want it?
Day after tomorrow, Your Lordship.
Day after tomorrow. We'll have it. On prayer made on behalf of the petitioner. This day after tomorrow. It will come in the motion column. Yes.
Apply, Lordship.
Item number 2.
Please, Lordship.
Yes.
This is the matter seeking quashing of the charge sheet under 14A of the Foreigners Act. Lordship, the
Yes.
charge sheet has since been filed. If I may be allowed to place a copy, put it on record.
You should have brought it in record by way of an affidavit.
Today morning only I have got it, Lordship.
You should do it. Because now your main petition was filed against the FIR only.
FIR and subsequent.
So now charge sheet has come. Now if you can well challenge
There
it.
is no
you see.
mention of the charge sheet in that main petition.
That is okay, but then Supreme Court says that it can be, you see, like during the course of the pendency of quashing, that can be, there is no
I'm
problem.
seeking for the pendency of the quashing of the entire case. Now, Lordship, interestingly in the charge sheet also,
Yes.
there is nothing in the charge sheet apart from my own statement.
Okay. And what your statement says?
My statement says, Lordship, there are two accused, two matters, two accused. It's an identical statement. They say that it is a fact that we have gone and crossed the border.
Okay.
Apart from that, Lordship, even as there is not a single indication in the charge sheet at all to remotely suggest that the allegation is...
Yes, Section 14 Foreigners Act, burden is on you to...
No, there, Lordship, I have a small submission to make.
Yes.
Lordship, under the Foreigners Act, Lordship, the burden of proof is on the accused, not for any offence, Lordship. The burden is to prove that he is not a foreigner. In this instant case...
So it is limited to that issue?
Only to that issue, Lordship. That whether or not a person who is said to be a foreigner...
Okay.
The reason, Lordship, as held in the case of Sorbananda Sonowal, reason was that, Lordship, whether a person is a foreigner or not, his nationality is something that is only known to him. It is not known to the prosecution. So that is why, Lordship, the prosecution cannot be told to prove something which is negative. So in that view, Lordship, the burden of proof has been upheld only for the purpose of proving whether a person is a foreigner or not. Here, Lordship, there is no dispute with the fact that they are foreigners. Allegation is, Lordship, the allegation is not they have illegally entered India as an infiltrator. Allegation is that they have crossed over to Bangladesh and come back to India. And they were caught in Dauki.
Assuming if you done it,
Lordship.
let us assume that that is correct.
Lordship.
Then what is, which way it violates? And what
Assuming I have done it, Lordship, it is a violation of my visa condition, in my humble submission.
So if it is a violation of visa condition...
It does not attract 14 capital A, Lordship.
But then here charge is under 14.
14A. 14A on the ground that I have illegally crossed over to Bangladesh and come back to India.
The violation of visa condition will make you liable under what section of law?
14E, if at all, Lordship. E. That is basically a misuse of the condition of the visa. Visa was for a particular purpose. I have violated the visa by going out and coming back. So to say that instead of a single entry, I have re-entered.
Now say supposing if this charge sheet is filed on the basis of your statement.
Lordship.
Now to contend that you have never made such kind of statement, will it be a proper forum?
No, I am not saying whether I have made this. I am saying that that statement is neither here nor there, Lordship. But had there been even a complainant statement saying that yes, I got an information that these people had crossed.
What is your statement? Just
nothing, Lordship. Kindly see the charge sheet, Lordship.
Are you ready for this? Oh, you have to bring it on record.
Lordship, and my difficulty is that in item 3, the petitioner's visa is supposed to expire on 11th, Lordship, of September.
Today is what date?
Today is 1st. That is the only, Lordship, the hard-pressing difficulty in the matter, Lordship.
And there is no provision of extension of it?
No, Lord. I have taken instruction. What they say is, Lordship, that as of now they have a valid visa. Now, if the visa is expired, they will be charged under overstay and all.
And what about the other person?
Other person, his visa is expiring in December, so some time is there. Lordship, there is no dispute with the fact that they are UK nationals having...
Both the cases are similar in identity.
Similar in nature.
Identical, same FIR, same charge sheet, Lordship. And same statement also. Word to word, same statement.
Today is the 1st.
I am only saying that for them to put the burden on me, they cannot simply, Lordship, put it on the basis of my own statement.
Bring this charge sheet on record, we'll have it...
I'll do it today only, Lordship.
We'll have it after tomorrow.
Lordship, please.
Both the cases.
Both the cases. Charge sheet is filed in both the cases, isn't it?
It's a common charge sheet. I'll file it only in one.
Just give it. Yes, it is submitted by Mr. Dev, Land Counsel for the petitioner. Then the matter has been charge sheeted. Stop. He submits it. The petitioner may be allowed to bring on record the charge sheet by way of an additional availability. Prayer allowed. List this matter day after tomorrow. Then we have to dispose it before.
Lordship, either way, that is my only
Please
prayer.
come with the law, you see.
Lordship, yes, I'll.
Do not leave it apart so that the court has to conduct some research.
No, I'll come with all the judgments, Lordship. Only my prayer is I'll file a single affidavit, Lordship, because it's the same charge sheet in both the.
No, you have to file. If there are two different cases, then you have to file two different affidavits.
In both the. Very well, I'll.
Definitely, that is what the.
Very well, Lordship. No issues. Objection.
Item number 6.
You are also there in the. Just a minute, madam. Union is also there.
The complainant. They are the complainant.
And
considering
then
the charge sheet
what is your stand here? We will not give you beyond day after tomorrow. Make it clear, whatever the situation. Yes.
Much obliged.
Yes, madam.
Your Lordship, I filed a affidavit on the 28th of August, Your Lordship, indicating that the department was not aware of the demise of the petitioner's husband, Your Lordship. Moreover, Your Lordship, the death certificate was also not submitted to the department.
Okay.
Hence, they could not initiate any proceedings, Your Lordship, to examine whether the deceased is eligible for
So
retirement benefits, Your Lordship.
Now, what do you propose to do?
Your Lordship, they can approach the department, Your Lordship, so that the department can examine the matter.
If you have not at all approached the department, why you are before this court?
Let me take instruction.
Lordship, moreover,
Moreover, the respondent number 4 has not filed the affidavit.
I've indicated that the deceased, Your Lordship, was a habitual absentee, for which suspension order was also
So you see,
issued.
you say that because of that he will be disentitled from the.
No, Your Lordship, I'm just trying to say that because of that, Your Lordship, the department was not aware that he had passed.
Okay. He has passed away.
Yes, Your
Whether it's a temporary passing away or permanent passing away. Isn't
Your
it?
Lordship, that's why we could not, the department could not take any
So anyway, do one thing. You take necessary instruction.
Yes, Lordship, I'll take.
You have received the affidavit.
Yes, Lordship, I have received the
So,
affidavit.
okay. You are for? Okay. Then what is your stand here? You will be filing affidavit.
I'll be filing a lordship itself.
You are respondent number 4, and you will be filing an affidavit. But then, what for your affidavit is needed at this stage?
Nothing
not
has
know
been
what is-
processed also, Your Lordship.
AG doesn't come into picture unless you forward.
Not yet, Your Lordship.
Even then, you want to file an affidavit. Anyway, it is submitted by MS JD Nompini Laniji appearing for the respondent number 1, 2,
1,
and
2,
3.
and 3, Your Lordship.
That is that an affidavit in opposition on behalf of the state respondent has been filed. Stop, however, Ms. E.B. Pasa, learned counsel appearing for the respondent number 2, respondent number 4, 6. Further, how much time?
1 week, Your Lordship.
Are you sure?
It's already been prepared, Your Lordship. It's just the signatures.
It is, you know how long it will take. The court will not know. So 1 week will be sufficient. What is it? So is the price for grant of further 1 week's time for filing affidavit in opposition. Stop. Prayer allowed. When shall we list it? After 2 weeks, within 2 weeks,
After
you
2
will
weeks.
list this matter after 2 weeks. You obtain instruction.
Yes, Lordship. I'll obtain.
If submission of the government is correct, then we'll close it. We will not keep it the matter pending.
Yes, Lordship.
Pension matters, we do not want to keep it.
Yes, Lordship.
And if that be the thing that have not at all approved the department, do not expect any order from High Court. You first say, okay, we'll have it. Meanwhile, you take the thing instruction.
Okay, Lordship.
Obliged, Your Lordship.
7.
Yes.
Yes, Your Lordship. Lordship, I have taken step for the private respondent number 7, Your Lordship, but still waiting for the delivery status report.
So what is to be done?
Lordship, kindly give me time to file my affidavit in service.
You will verify the status.
I'll verify and I'll.
Okay. The official note indicates that the report of service of notice upon the respondent number 7 has not arrived. What about other respondents?
Lordship, there is only one private respondent, Your Lordship, the second wife.
And who is? Oh,
1 to 5.
Ms. Pasa 46. Okay. Okay. What is it? Has okay. Okay. As for on behalf of the petitioner. As prayed for. Stop. How much time? 2 weeks time.
2 weeks time, Your Lordship.
As prayed for, comma, the petitioner is allowed to verify the status of service of notice upon respondent number 7 and file an affidavit to that effect. Stop. Then you say list up after 2 weeks. List up.
Lordship, obliged.
Meanwhile, you file your
Yes,
thing.
Your Honor. We are awaiting instructions.
7 is what then? This
The
is
second wife, Your Lordship, is a dispute between the two wives
Okay,
regarding the
pensionary.
pensionary beneficiary.
how this court can help. how much help it can be done?
Lordship, there are two wives in this matter, and the department has sanctioned the succession certificate in the name of the second wife, not for the first wife.
You were the first wife?
I'm the first wife, Your Lordship.
No, get that succession certificate cancelled.
Your Lordship, that's why you are before Your Lordship.
That has
because
been
there's
done.
some dispute.
Cannot go by the writ petition. Maybe you may have your remedy elsewhere. Just see.
Your Lordship.
Okay.
Oblige, Your Lordship.
Hearing item number 10.
Yes.
Lordship will recollect in this matter regarding that plot number 267.
Oh, sure.
So we had stopped at the point, Lordship, that what was the list given by the petitioner to the inquiry officer? Because the issue cropped up, Your Lordship, on Mr. Bhattacharjee, his statement was recorded in 2009. In 2009, but the court had passed an order on 26/9/2013 and said conduct an inquiry. So the petitioner has made out a case saying it has vitiated the inquiry because of the statement of Bhattacharjee.
Okay, it was recorded at the earlier stage where they had no chance.
That is at paper mark, we have flag marked it at flag mark 4. But actually flag mark 1 is the order by the inquiry officer. Flag mark 2 is very important, Lordship. Flag mark 2 is the document support submitted by the petitioner before the inquiry officer. Flag mark 3 is the deposition of Minar Kantade, and flag mark 4 is Bhattacharjee. My argument, Lordship, was that Lordship will kindly see flag mark 2 is very important. What was the document submitted?
We just will pursue it. We will just not keep the record with us. If it
Lordship, absolutely. Lordship, we just wanted to be inquisitive as to what was exactly. So Lordship will kindly see.
Flag mark 2, there is no flag marking here. Flag
No,
is
not,
here.
not marking, sorry, just
Second flag.
second flag
yes,
mark.
yes, it's there. It's there. When the marking has been placed inside.
Lordship,
So
flag
the very purpose of marking is frustrated.
Okay.
It's defeated rather.
So Lordship,
Yes.
kindly see the list
Flag
of
mark 2.
documents.
Flag mark 2 appears to be a statement.
And just see the documents that he has submitted in the list. We just get it.
Flag mark 2 is the statement of the
Yes.
petitioner. Okay. Copy of prayer for allotting plot number 267.
Yes. That list is very important, Your Lordship, because that will address the issue of whether possession certificate was.
Copy of petition of lease of plot number 227. What is meant by the second one? The copy of petition of lease of.
That was like 1957, Your Lordship. Certain conditions had to be complied. It's also annexed there.
Okay, so this allotment was made on the basis of some prayer. So first one is the prayer. Second one is the petition of lease.
Petitioner like asking them to grant the lease in favor of petitioner.
So first one is then what? Essentially, then how can there be two different things? If it is first one is for prayer for allotment, second becomes the same thing again.
Lordship, yes, same thing.
Copy of refugee certificate, and documents related to. But then we have these documents. What bearing it will have? There is no dispute to the
absolutely,
fact
Lordship. The inquiry,
that it was allotted, but then they have never accepted.
Absolutely. So, Lordship, what had happened in the inquiry officer returned the finding that the position was not taken also. Lordship had read it out in detail. So then the query was raised that the document of 2009 was relied. Now 2009 document is, we have marked it at paper mark page 4 Lordship. Lordship will see. Flag mark 4. So it's 2009. Order is of 26/9/2013. High Court's order.
You have a copy of the statement of Mr.
They all have it.
No, my lord, we don't
Niranjan
have. We don't have. We were never supplied with those statements, my lord. We first came to know about it when the inquiry report was given to us.
So before that you have
No,
you
no,
had no
my lord,
knowledge.
we had
about
no occasion even to cross-examine him.
cross-examination comes later. First,
they
that you
relied
should
on the
have a
document.
knowledge that whether a person
We
is
had no knowledge whatsoever, my lord.
But Lordship will kindly appreciate this was a document of 2009. Their only limited prayer is this has the inquiry officer should not have relied on that.
See, Mr. Khan, so far as the merit of the decision, this court has no interest to.
Absolute, Lordship.
Do not, we should not also, because our jurisdiction that is restricted. But then what this court would like to see that since something has been referred in the inquiry, and if it is a statement, whether it is relevant or not relevant, we will not go into for purpose of this. We will just see whether copy was given to them or not, and whether they had the opportunity to refute it or not. What is the content of it?
Absolutely correct, Lordship. You know, I'm
until and unless
Lordship, I'm not into
there's some purpose.
Lordship is very correct. Until unless there is some purpose, the purpose of this letter is
perversity, not perversity.
Irrelevant. Even Lordship, while arguing, supposing this we overlook this letter.
Anyway, then why don't you supply him? Supply him a copy of this. Let him go through this for his satisfaction. And then you can definitely raise that this has no relevance.
Okay, Lordship. As a Lordship, please.
Without giving a copy, it will not be unfair for you to see.
Absolutely correct. We'll give him a copy then, yes.
This one page you can xerox and you can give it. So at least
he'll be aware of it.
Probably now this court recollects that we called this record only for the purpose of satisfying the issues raised by Mr. Thapa, because his thing was that you see like the materials related by the inquiry officer.
Yes.
Never supplied.
Not known to the petition.
Not known to the petition. So court
that is why you want to sue, isn't it?
That is one of the aspects, my lord.
And the court wanted to know.
You just see it. So apart from this,
there's nothing.
Apart from this,
nothing. This is the only
submission whether has any connection with the record. Otherwise, you will not retain
my lord
the
may also see, my lord, my statement and the documents that I have supplied. That I have come to know just now.
Mr. Thapa, you see, until and unless you can project some perversity, we would not go into the documents to assess what is there and what is not there, and whether a second view could have been possible or not.
My lord.
Even if you convince us that yes, a second view was very well possible, that even cannot be a ground for interference in judicial review.
No.
So that is, primarily we are concerned with the decision-making policy, nothing else.
No, Lord.
You have a copy of this? And
Lordship, we'll give it. We'll give it to him today itself, and Lordship can have it after maybe 2 weeks or next week, anytime.
No, that is up to the convenient of the thing. Mr. Lindo must be waiting for his turn to come. She's thinking when this hassle will be over so that I can get a chance to speak.
Lordship, the matter is entering its decade now.
He is getting impatient. He wants to demolish the petitioner. So, that is what. No, but then if this statement is not given to him, let him go through the statement, and then we will decide. But then one thing would remain the question, you see. If inquiry officer has rightly or wrongly referred to something, was it not proper for him to supply it? And will it not sufficient enough to say that he has been prejudiced by non-supply of this?
Lordship, absolutely correct. We have to just address the issue of prejudice.
So we have to see what is there in the copy.
Absolutely. I am grateful, Lordship. That is the purpose. That's why I said we'll give a copy to him. Then we will argue that once we give a copy to him when we come next time.
Okay. Just in person to the, when you were directed to produce the...
Lordship, I think sometime in the month of July, Lordship, 15 or 16, 15 July.
Are you sure?
Just check.
16th of
July.
It's very, nowadays this court is...
16th of July.
16th July.
July, Lordship, yes.
Okay. In person to the order dated 16 July 2025 of this court. Mr. Khan Learned AG has placed on record the relevant record before this court. The appraisal of the record reveals that apart from other documents are available on record, the inquiry officer has taken into cognizance a statement made by one C. Nilanjan Bhattacharjee with regard to plot number 12 of Umpling Arar Colony on 29/9/2009. Step. Mr. Thapa, learned counsel for the petitioner, said. Petitioner submits that Mr. Thapa, learned counsel for the petitioner, submits that the petitioner was never made aware of existence of any such statement and was not supplied with a copy of the same at any point of time during the course of the inquiry. Stop. However, the learned AG maintains that though the statement has been referred to by the learned by the inquiry officer, it has no material bearing.
Lordship.
It had no material bearing in the inquiry. Stop. This paragraph, taking into consideration the above circumstances, it is directed that a copy of statement of late Srini Lanjan Bhattacharjee made on 29/9/2009 as referred to in above shall be supplied to the learned counsel for the petitioner within.
We'll do today itself.
Shall be supplied by the state respondents. Within 2 days. 1 day, within a day, or during the course of the day.
Absolutely.
Stop. Then when shall we have it? After
2 weeks, Madam.
Up to him, Lordship. We'll give it to him.
It's up to you. Should be okay. Okay, then just say straightforward with the parties. List this after
2 weeks.
List this matter after 2 weeks. That's all right.
All right.
Record. The departmental record produced is hereby returned back.
Lordship. No, take the give it to him also. And get it received now.
To Mr. Rinja. You returning that?
Lordship.
Learned G.
Yeah, we'll give it to you.
For transmitting the same back to the department. Is returned to Mr. Rinja, learned G, for transmitting the matter back. So we can return the record. There will be no issue with the record now. We will not retain it unnecessary.
There is no reason for retaining, my lord.
Yes. That will be better. Hopefully next week we can finish it. That is all right. This order will suffice.
Absolutely. Absolutely.
Just return it.
Well, only, my lord, can a permission be given to us to examine it once, my lord, before it is sent back?
You want to go to the record? Yes. Is there any bar for them?
Yeah, I don't think so.
You
because
can do it in your thing. You see, Mr. Khan is
I'll
there.
come to his office.
You will ensure fairness.
Yes,
Mr.
absolutely.
Renja, just if possible, just before you returning back, allow him. We are not passing any order.
Right.
Just go through it.
Yes.
Take it. No,
Today itself will.
And if you find that something is there,
I'll make
you
a
may
note.
write these things. Tell him not to return it and mention it to the court that let record not be returned.
All right.
But then you will examine it in his presence.
Right. We'll do that now.
And offer him a cup of tea also.
Of course. All right.
29.